Good morning, good afternoon to all the participants. Welcome to this section of the IBA meeting, virtually getting together. We will discuss today issues linked with the arbitration, with legislation, and we will focus on different cases with our participants, with our speakers, who are very well known of lawyers, legal experts in their respective fields. We will have Annabelle Thomas from Mission de Rea from London. Welcome, Annabelle. Annabelle is an experienced commercial litigator with a strong background in corporate disputes and all aspects of civil fraud, including asset tracing and injunctive relief, partnership disputes, company and shareholder disputes, joint venture disputes, LLP disputes, and breach of warranty and indemnity claims, insurance disputes, competition law, regulatory and disciplinary litigation. So Annabelle's practice covers litigation in the High Court as well as in arbitral proceedings. Our second speaker will be Emmanuel Sora. Welcome, from Alexion Pharmaceutical Company from Switzerland. Emmanuel is a senior director in the in-house legal department at Alexion Pharmaceuticals. And he's based at the company's international head office in Switzerland and providing legal support for the company's commercial operations across various markets within the international region. He's qualified as a solicitor in England and Wales. From Singapore, welcome Edmund Cronenberg. Edmund is the managing partner of Bradell Brothers LLP, Singapore's second oldest independent law practice, founded in 1883 by the sons of Singapore's first Attorney General. He's admitted as an advocate, solicitor in Singapore and solicitor in England and Wales. He also has rights of audience at the AIFC court in Astana, in Kazakhstan, in Astana's International Financial Center. And he has over 23 years of experience in dispute resolution, litigation, and arbitration, regularly appearing as counsel before the Singapore courts, as well as in international arbitrations all over the world, and especially everywhere, almost in Asia. His diverse practice includes commercial and corporate disputes, breach of confidence, defamation, medical negligence, employment, energy and natural resources, media and telecommunications, as well as preemptive relief and injunctions. He is not only a member, and he sits as arbitrator to regard Asia, but also he is well known in many international institutions, and also honorary overseas member of both COMBAT, Commercial Bar Association, England, and the Chancery Bar Association, and IADC, International Association of Defense Counsel, headquartered in Chicago. Our last speaker will be from Turkey's leading law firm in this field, Gün and Partners, Pelin Baysal. Welcome, Pelin. Pelin has been with Gün and Partners since 2006, and she has been a partner since 2013. She is the chair of the firm's dispute management practice and has acted as party counsel and in and advised on numerous commercial and corporate disputes before the Turkish courts and ICC arbitration, involving mergers and accusation disputes, disputes arising from international sales, high-level insurance disputes, and directors and officers liability disputes. So she represented many clients in enforcement of foreign court judgments and arbitral awards. So, ladies and gentlemen, our topic today, of course, is linked with what we are living through, the pandemic. It is having more and more impacts, despite lots of measures taken already with the now so-called the first wave, and we can simplistically define ourselves now as navigators of the second wave, trying to avoid a third wave of confinement and surge, of course, in cases. But definitely, it has been a game changer factor in our daily lives, individual lives, family lives, institutional lives, social lives, economic lives, in politics. And the game is changing or has been changed already. So my first question to all the speakers will be the same. What is the impact of COVID-19 on dispute resolution? Is it very bad? Are we adapting? How, content-wise, logistically? How the things are going? Starting with Annabelle, please.
Thank you very much, and thank you for the introduction. It's a huge pleasure to be here with you today. As you say, I'm a commercial litigator based in London, and I've been doing this job for a long time. And I think as commercial litigators, we're quite used to being counter-cyclical. If things are going wrong in the world, usually the litigators are busy. And there's no difference here. Some non-contentious practice areas in the UK did take a hit at the start, real estate and corporate, but that is starting to pick up. But for commercial litigators, what COVID has led to is an increase in certain types of cases. So predictably, I'm seeing more inquiries about breach of warranty disputes, about JVs that have gone wrong, directors who've been accused of neglecting their duties, unfair prejudice petitions. So that kind of work is definitely on the increase. And of course, civil fraud, because anytime there is a worldwide economic crisis, that is when civil fraud either happens or people are accused of it. I know that lots of my clients are looking at their default risks, their force majeure clauses, their material adverse change clauses. And of course, my colleagues in insurance have been very busy. They were in the Supreme Court here last week in relation to business interruption cover. The difficult thing, I think, for litigators when COVID really hit was making sure the wheels didn't come off the bus. We're still, limitation dates didn't change, court deadlines didn't change, so we had to make sure we carried on working. And our IT team, luckily, had already got us well on the path to flexible working. In terms of the courts, some sectors of our court service have suffered very badly and have a very significant backlog, like the magistrates' courts and the criminal courts. I practice mainly in the commercial court, and I think all the hard work we did in terms of flexible working would have come to nothing if the court service hadn't done the same. And the way in which the courts have responded to this unprecedented crisis has been quite remarkable. So we have virtual hearings. I'm at the moment involved in a lengthy trial which is being done fully remotely. We have witnesses in various different jurisdictions, and it is all being done remotely, with the judges able to deal with Zoom, with Teams. In terms of how a trial runs when you're doing it virtually versus physically, I still am old-fashioned. I still prefer being physically in a courtroom. You can see the witnesses, you can see how they're reacting, you can look at how the judge is reacting, and you can read the room better. But have we got a feasible workaround until we can be back in a courtroom? Yes, we have. So I think it's been a challenge. But it is so far for commercial litigators working pretty well. And I think there's been bonuses like time savings, and I think it's also greener. We're not printing out tons of bundles and lugging them to the court. So I'm hoping that there will be an environmentally positive impact as well. So that's a very brief synopsis of the position in London.
Thank you. Thank you very much. Emmanuel Surab, from the angle of in-house counseling.
Thank you, Bahadir. And also, it's a tremendous pleasure to be here and share my experiences on this panel. So I'll offer more the perspective of an in-house counsel, meaning that actually fairly little of my practice is disputes related, but I support the business on a wide range of transactional and advisory matters. And so I'm happy to offer that complementary perspective today. So as you may know, in the pharmaceutical industry, quite a lot of the contracting and the activities we do revolve around congresses and engagements with doctors and speakers. So initially when COVID struck, I mean, we were faced with a kind of wave of commitments that became either impossible or extremely difficult to meet. So we had to manage these kinds of issues. And the reason for that is that because the contracts or the activities involved actual physical meetings. Then came the time when the organizers of these events got organized and offered contingency plans. But then the question was more whether these contingency plans really offered value for money. So we had lots of discussions. We supported the business to determine a legal strategy where, the business was just not happy with the contingency plans being offered. And then as time went on, more and more parties wanting to insert clauses and agreements for future activities, seeking to exonerate themselves in the event of a prolonged pandemic. And so you might think this is all fertile ground for litigation. I think only time will tell at this stage, but it certainly led to an uptick in work for my department. On the dispute side, I mean, we experienced the sort of phenomenons that Annabelle mentioned, court, I mean, probably, I would say jurisdictions outside the UK, I mean, some of them were not as organized as perhaps the UK court system. So we've experienced, some court hearings being adjourned and everyone needing to be patient around that. And then the last thing I would mention in terms of advisory work would be, simply supporting the company in adapting to this environment. And in particular, the crisis has accelerated the digitalization of the company, which means that the company has been seeking more tools, to support its field force, for example, to do their work properly. And so this has generated more work for our department. I mean, then on a day-to-day basis, you have the usual kind of issues that everyone has faced around Zoom fatigue, too many meetings. I mean, what I would say is that it's sometimes been a bit more difficult to obtain just executive engagement and senior management engagement on issues where previously it might have been a little bit easier. But it's really for the major issues, it's not been a massive issue. We were used to a certain extent to operating digitally. And so I would say that this has kind of accelerated that movement.
Thank you. Thank you very much. Edmund, you are not traveling anymore?
Yeah. Well, thank you, Bahadir, and thank you again for having me on this panel. It's a great privilege to be here and a great pleasure as well. Let me share my what happened in Singapore when the COVID pandemic started to get really serious in Singapore. Obviously, the courts were stopping actual hearings, physical hearings. We were told that we couldn't go to our offices, that we had to meet clients on Zoom or via telephone. So there was a period of time where obviously we had to get used to operating outside of our offices. The courts too, I think, were wondering how long this situation was going on for. Arbitrators were wondering how long this was going on for. So to a large extent, I think the first reaction that we saw in Singapore was to try and put things on hold for a little while until people figured out, whether this would be 2 weeks, 4 weeks, 6 weeks, what would happen. And therefore deadlines were extended, hearings were pushed down the road, travel was suspended. And then we came to the realization this isn't going away so fast. It's not just this part of the world, but everywhere in the world that's affected by this. We're going to have to make some real plans. And I mean, to be quite blunt, what happened is you would find one part of the Singapore legal sector clinging to its old ways. Some people, some small firms, in fact, I've been told closed for 1 month, and then they were told it had to close for another month. And I think some people have retired from practice. But by and large, about 80%, 90% of the Singapore legal profession decided to adapt, got used to working on Zoom, started to buy good cameras, good microphones, speakers, that kind of thing. So we could actually get into court hearings, which were continuing on Zoom, and carry on with our arbitration hearings. And we've been adapting ever since. I haven't stepped into a physical courtroom since around March, doing everything online. And, unlike Annabelle, I found a way to get to read the room from my screens. But that requires, that's an answer for a different question that requires some adaptation and, some serious hardware. So that's what's been happening in Singapore.
Well, thank you very much. Pelin, how the Turkish courts operate? How do you operate?
Thank you, Bahadur. Of course, first of all, like other jurisdictions, the litigation is on rise on a wide range in Turkey too. Particularly the contract disputes, employment disputes, insurance disputes really keeps us busy. What I feel is that the clients are less patient for waiting for amicable settlement or waiting for payment. It is a difference what I feel in this COVID-19 pandemic time. When we look at what happened in Turkey from beginning of COVID in terms of the court, it's unlike really Singapore and London. In mid-March, just after the first COVID-19 case in Turkey, the government took immediate action and determined measures to be taken in scope of COVID-19. Accordingly, all courts were encouraged to postpone the hearings and on-site examinations. During this term, attorneys were able to track these postponements through UYAP. UYAP is a central electronic network that allows judiciary units and attorneys to carry on legal process and communications digitally. Having such a system at our disposal, of course, served as a great advantage to minimize our physical presence at courts. Then later in March, legal arrangements were made to suspend all enforcement and bankruptcy proceedings across the country with some exemptions. Furthermore, all terms in scope of the acquisition, use, or extinction of a right, including the terms for filing lawsuits, notices, submission periods, and time limitation periods were suspended until April 13th. Soon after, the government issued additional measures, and then it became, then the courthouses became non-functional at all. All these postponements were further extended until 15th of June then. So courthouses started to function as of June 15th with protective measures implemented to minimize the transmission risk. However, the operation of the same was quite limited until the end of judicial recess, which brings us to September. So at first, it was even problematic to enter the courthouses and particularly to the public prosecutor's offices. The officers questioned the kind of work to be conducted in detail before allowing anyone inside these rooms. We also encountered cases where several front desks rejected physical file and document exchange. Although these measures become rather looser in time, courts still impose certain measures to protect judicial staff and other citizens. For example, some courts do not allow any audience or more than one attorney inside the courthouse. On a separate note, of course, during the course of pandemic, there has been a recent amendment to the civil procedure, the Turkish Civil Procedure Code, which allowed the courts to conduct remote hearings through video or audio transmission, either on the party's request or ex officio under certain circumstances. Although this is still in the test stage and only available in certain courts, including those in Istanbul, I think it will become more widespread soon. So in short, nearly all litigation proceedings were suspended for nearly 6 months. And now, save for certain quarantine restrictions on some courts and bankruptcy offices, the courts are well functioning. On the other hand, when we look at the arbitration proceedings, for example, I experienced no difficulty at all. In one of them, the seat was Istanbul, the governing law was German, and we were the lead counsel, for example. And in that arbitration, the arbitrator really scrutinized whether or not there's a need for a hearing. Other than that, I think it was a smooth transition in terms of arbitration. So it's what I experience from Turkish law perspectives and Turkish courts.
Thank you. Thank you very much. At this point, I would like to remind to all the participants that they can join the debate with their questions. Please use on the bottom of the window the Q&A, not the chat, but Q&A menu. And you can write down your question for everyone or specifically to one of our speakers. But please do so and please join the debate. Now, all right, well, there is, the human beings are, we have the capacity to adapt. The institutions sometimes they do it better than the general public. Sometimes they are late. And sometimes, of course, the evolution, the gradual change is so unexpected that we feel a little bit in a vacuum, although the next steps are very clear and very imminent. One of them is the vaccine. So may I add to this first round an additional question, starting again with Annabelle. What do you think about that, and what do you think on the debate around this topic and on the daily practice? Are there already disputes or resolutions stemming from the upcoming and well-awaited, well-expected vaccines?
Well, it is very encouraging news about the 3 vaccines, and we're delighted to hear it. Obviously, I think they will open the door again for business travel, and for a firm like Mishkon's, where the bulk of our clients are overseas, the bulk of our disputes involve different jurisdictions, that is going to be quite the game changer coming in. In terms of litigation coming out of the vaccines, I fear it is inevitable to a degree. There has already been so much litigation coming out of COVID, particularly in the UK, in relation to provision of PPE. There's going to be disputes about procurement, about lockdown. As I mentioned before, some of my colleagues are in court, Supreme Court last week in relation to business interruption losses. So whether there will be disputes about how the vaccine is deployed, who has to have it, I'm sure, and I suspect Emmanuel will be better placed to talk about this from an in-house perspective, but the COVID-related contractual clauses are going to be inevitable. Just as a sort of amusing side note, we have an 800-year-old charter in the UK called Magna Carta. It has absolutely nothing to do with COVID at all, but a number of people have mistakenly tried to rely on it to get around the lockdown regulations. So who would have thought an 800-year-old charter would bust it out for that, but it has been.
It is still certainly relevant to explain to the students of law or political science what the democracy is about, but as an historical artifact, of course. Emmanuel?
Thank you. Just for clarity, my company doesn't manufacture vaccines, so this is not at all a part of our business.
Our sector, of course.
I just wanted to be clear for the audience. But so for us, it's more of a sort of environmental factor, if you'd like. Of course, it's tremendous news. It's sort of giving, I think it's giving teams more confidence in going ahead with their projects as they plan for 2021. So, you know, it could be that some of the contract changes we're seeing may actually not come in, you know, never become the subject of discussions or litigation. And I think that's a good thing, because all the language that's, you know, being discussed around inserting the pandemic as a form of force majeure and these sorts of things, we're just hoping not to really having to rely on it or kind of trigger these clauses in practice. So I think that's really nice news in the sense that it sort of removes the risk for business disruption in the future, hopefully, you know, as vaccination campaigns get rolled out.
Thank you. Edmond?
Thanks, Bahadur. You know, obviously the vaccine's going to be great news for Singapore. We are a meeting hub, travel hub, arbitration hub. And so, I mean, the fact that we've had to close our borders for several months now has impacted Singapore quite heavily on a financial front. For lawyers as well, I share Annabelle's views. I mean, a lot of our clients are international. We want to see them. We want to get over to countries in the ASEAN region like Indonesia, the Philippines, where a lot of work is going on, in Vietnam. But I have to say, the prospect of a vaccine can sometimes stifle, in my field, an arbitration going on. Because if you don't know when the vaccine's coming out, then you make plans to carry on virtually, you carry on remotely. But with the vaccines on the horizon, you can imagine a lot of people coming back to say, hang on, let's not do a virtual hearing, let's just wait for the vaccine to come out. And that, just because you have a vaccine, it doesn't mean that you're going to get the vaccine tomorrow. I mean, there's a rollout process. So that might be 3 months, it might be 6 months, could be 9 months. But now people have a good excuse to say, let's not get on with this, let's do a physical hearing. And let's see what happens, to the arbitration world when that argument is made, because I imagine it's happening right now.
Of course. Thank you. Pelin?
I totally agree with Edmund. As a matter of fact, it's going to be used as a excuse to delay the hearing or to have it in person for the arbitration cases. For litigation, I do not think that there's going to be an effect. But of course, it's very, very important for Turkey, because Turkey is waiting for tourismus for 2 years, and it's a huge impact. It also gives, or it also encourages the people like us to live with measures for a limited time. Otherwise, we are really trying to keep ourselves, we are at homes, or we are wearing masks, having these measures, but how long? We don't know it. So it really gives us a hope, and it's a great news, I think.
Thank you. Annabelle, what are your observations on the tangible impact of the COVID-19, of the pandemic on the profession, especially on the notions of dispute, for example? Is there a difference in your client's approach to litigation before and after the COVID? Are there already observable trends?
I think so, yes. I think for a lot of our clients, it has brought various things into very sharp focus. Litigation has to make sense. The litigation risk has to make sense financially. As we all know, for our clients, entering into litigation takes up a huge amount of manpower. So they are very keen to look at ways in which that can be managed, that can be reduced. So I'd say they're more focused than they were on value for money, quite rightly. There's been much greater interest in alternative dispute resolution. So I'd say in the last 6 months, I've done more mediations than I had done in the previous 2 years. And I'm happy to tell you that virtual mediation works pretty well. So that has been a real boon. They're interested, my clients, in how tech can help them. So we have a lab at Mishcon where we have tech startups in the legal sector who come and test their products on us, and we help them to get started. And some things like there are products like Solomonic, like Ping, which help drive efficiencies, which mean that litigation can make much more sense for a client than it would have done, say, a year, 18 months ago.
Oh, yes. Emmanuel, risk management or risk mitigation, are we in a new era?
I wouldn't say, that my approach or my department's approach or tolerance for risk has changed because of COVID. I think fundamentally we're dealing with the same set of laws and same enforcement trends than we were in the past. But definitely some adaptations to the environment. I mean, so one difficulty is, this 100% virtual environment means no opportunity to meet clients in person. And I think it was something similar to what Annabelle said about she prefers to be in the courtroom to actually get a feel for for what's going on. And it's the same in an in-house business environment. It's important to spend time with business clients to understand what their concerns are, if they really understand the sort of legal issues on which you train them periodically. And so we obviously lose that opportunity in a purely virtual environment. One possible risk factor that I would worry about is more discussions taking place in writing as opposed to in person, because people cannot meet. So whether it's obviously that could potentially leave a damaging record, which could be harmful in the event of litigation in the future. And then my other concern is, with everyone working remotely, perhaps some individuals not appropriately distinguishing between personal and professional records, and that possibly being damaging in future litigation. But there are ways to mitigate these risks. So obviously, one way to do it is via further regular training. So we continue with our training schedule, and in fact, increase it wherever possible. And not drop the ball in terms of joining business discussions that are not purely legal, that are not related to a transaction or a litigation that I'm working on, but simply regular business updates, being in the room and continuing to ask questions so that we can continue to kind of spot issues before they become legal issues. That's a really important component of our role as in-house lawyers, and I think one that's more crucial than ever in this environment.
Edmond?
Yeah, well, I think the biggest change that we've had to deal with is in terms of how we actually advocate for our clients, and this sort of like links to my point on virtual hearings, which have become the norm now. Some people have hailed this as well. It's great for cost savings. It's absolutely wonderful because, you don't have to travel. You don't have to be away from family. You can wake up in the morning and go to a virtual hearing. You save a huge amount of time. But at the same time, it's a question of adapting to this new normal of virtual hearings, which I don't think is going to go away in the arbitration sphere. And, it's very easy to say, yes, we're okay with virtual hearings. In Singapore, we've been doing court filings, for example, electronically for 20 years. So we're very okay with sending in documents on email and stuff. But when it comes to the actual virtual hearing itself and arranging it, there's a whole host of problems that people have had to sort out, which we have had to do in Singapore. You obviously have to get used to the software. You've got to have the right hardware. In front of me right now, I've got two 27-inch screens, a high-res camera, a good microphone, things like this. And you need to know how to use all of that. We've had to adapt to time differences because, you can start a hearing at 3 p.m. in Singapore, but it's 9 a.m. in London or something like this. And you get tired looking at screens. So you take more breaks. Some people, can't stay glued to a screen for 4 hours. You try it. We've had to learn how to speak more slowly and clearly, especially when there's translation going on. We've had to deal with the risk, the additional risk of witness coaching, because, you could have, if the arbitrator can have several screens and the counsel can have several screens, then the witness can have several screens with the answers popping up on the screen and what to say. And we've had to deal with practical ways of having to sort this out. One example I always like to give is it's a great idea from a Korean arbitrator friend of mine. Set up a second link with a mobile phone, have a piece of blue tack at the back of the phone and stick it on the wall, and have a second link at the witness so you can see the witness from the side. You can see he's not getting prompted. All these innovations have come about as a result of us having to cope with virtual hearings, how to deal with electronic bundles, maybe not using electronic bundles. I know Annabelle mentioned something about saving the planet, but I found that actual hard copy bundles, which are printed out, you can send them electronically, that's not a problem, but you have them printed out, clear pagination, speeds things up very, very much. And, ensuring also that the guy you're talking to has the right hardware, because you may have wonderful hardware, but the tribunal has a little mobile phone like this, and he's looking at the witness like this. It's not going to work. So you have to ensure that the guy you're trying to persuade has the right hardware. So we've had to cope with with all these things as a result of the new normal.
Are there disputes stemming from the use of these new technologies?
Oh, yes.
Is it making more harder or something deeper?
Well, I can tell you where the disputes are happening. We need to ensure, let's say in the arbitration sphere, that you can actually do virtual hearings. So the first port of call is you look at the seat, you look at the Lex Arbitra, and you ask whether or not the law at the seat allows you to do virtual hearings. Because if it doesn't, or if it prohibits it, and you go ahead with the virtual hearing, then your award might be set aside later on. If the law doesn't prohibit it, you look at the rules to see whether the rules allow it. Singapore allows it. No issue with the law, no issue with SIAC rules, very progressive. Indonesia didn't allow it. The Bani didn't allow it originally, and the Bani had to issue an order to allow it. Vietnam still doesn't allow it unless both parties consent. So there is the potential of disputes arising out of virtual hearings. One party will say, you know, I can't afford the setup. I don't have the tech expertise to set up myself so I can question witnesses or present the case. The other side has much better tech than I. It's unequal power in terms of, you know, presenting the case. So I don't have a fair opportunity of presenting my case. Yeah, sure. All these things have arisen as a result of virtual hearings, these potential disputes.
Wow. Thank you. Pelin, how does it go in Turkey?
Not from Turkish point of view, but I really would like to explore a little bit what Edmund told about the virtual hearings, and particularly if one party does not agree on the virtual hearing. Yeah. There's a recent Austrian High Court decision on that. It's the first case, and maybe we can speak about it. So, the cases in which one party requests a remote hearing while another opposes it raises an important question, really. The tribunal has to balance important considerations. First, the party is right to be heard and they are treated equally. And the second is the tribunal's obligation to conduct the proceedings in an efficient and expeditious way. There's a discussion, there is a scholar discussion on that issue. On the extreme parts, one extreme, some state that a remote hearing is possible only if the parties agree on that. This view is based on the principle that if a party requests a hearing, such hearing is required to take place due to parties' right to be heard. On the other extreme, some suggest that arbitral tribunals would have unlimited authority when it comes to determining remote hearings in the interest of the procedural economy. So, as it happens, the truth lies somewhere in between. And the ultimate test, as Edmund said, for the remote hearing is whether this is going to be a challenge in the enforcement and set-aside stage. So in this context, it's important to recall the Australian Supreme Court decision. Let's look at the facts of the case and we can go on that. So as to the facts of the case, the parties discussed the possibility of a remote hearing due to COVID-19 pandemic. The respondent rejected this option and proposed that a hearing to be conducted in person at a later date. However, the tribunal decided that the hearing would proceed as scheduled, but through a video conference. The start time was ordered as 3 p.m. Vienna time, the time zone for the claimants, and 6 a.m. Los Angeles time, the time zone for the respondents' counsel and the witnesses. So the respondents filed a challenge with the VIAP board against all three arbitrators. The respondent had argued that the tribunal's decision to start the hearing at 3 p.m. Vienna time is an unequal treatment of the parties, because other party is going to has to be ready at 6 a.m. Local time. Secondly, the respondents argued that holding a remote hearing amounted to a violation of tribunal's duty to treat the parties fairly, because the tribunal did not put measures in place to prevent witness tampering. So what we mean with witness tampering is specifically the respondents claimed that neither the tribunal nor the parties were able to ascertain which documents witness would have access to, whether there were other persons present in the witness room, and whether witness would receive chat messages while being examined. After the challenge was rejected by Whiteboard, the respondents filed their challenge with the Supreme Court. On the first argument, the Austrian Supreme Court held that the respondent had, in principle, accepted the disadvantages resulting from the geographical distance to their place of business, including substantial travel time and time differences, because the seat was Vienna and they were coming from Los Angeles. In addition, the court noted that the disadvantages were not worsened by remote hearing at all. Starting a hearing at 6 a.m. local time was less burdensome than having to travel from Los Angeles to Vienna for an in-person hearing.
Virtual jet lag.
Maybe. So as to the second argument, the witness tampering issue, the courts held that blanket allegations concerning the potential misuse of the video conferencing technology in examining witness could not render them inappropriate. The court found that the risk of witness tampering also existed in in-person hearings, and that remote hearing also allow for measures to control witness tampering that going beyond these available at a conventional hearing, in-person hearing. Just like Edmund's Korean friends with the extra phones. So after refuting the respondent's argument, the Austrian Supreme Court confirmed that as a general rule, remote arbitration hearings are not only permissible if both parties agree, but also over the objection of one of the parties. So I think it is very, very important for us. So this is the first High Court decision on this matter. And of course, we expect to receive more from different jurisdictions, and we will evaluate once we receive them in the future.
Thank you. Thank you very much. Well, in this last round, I would like to give you floor to every one of you with your not only conclusions, but also the analysis for the prospects for future scenarios, or the main parameters that we should be looking for to better maybe understand what will happen next, and also your recommendations maybe to your colleagues and to everyone who's interested in dispute management issues. Annabelle, please.
Thank you. I think over the coming months, we will continue to see a rise in business disputes. So I think we're going to see more joint ventures falling over. I think we'll see more claims for breach of warranty, for breach of indemnity. I don't see that changing. I think that will increase quite significantly. I think more firms in London will embrace the tech side of things to help our practices. I think there have been, if I could go through quickly, a couple of positives to come out of COVID, in that as a team, we were very conscious that a number of our fee earners lived alone or had very significant caring responsibilities. So we had a rota whereby the partners in our team would call associates, paralegals, trainees on a regular basis to check in with them, and not to talk about work, but have a discussion about family, how things are going, what support we could offer. We have an online GP service. We have an online system that helps people find nannies, find carers for elderly parents. And taking the time to do that has worked out really well. And I feel that as a team, we've managed to become closer perhaps than we were when we were sitting physically next to each other in the office. So I very much hope that continues. But I think on the tech side, we are seeing, out of every major economic crisis, there are inevitably some amazing tech developments that wouldn't have happened had it not been for that crisis. And we're starting to see them now. And I hope that we continue to capitalize on them and use them to improve our processes and help us work better for our clients. So I think that is a positive that will come out of this horrendous last few months.
What about the people joining your team recently? Are there any cases of?
We have had a number of new joiners join the firm, and that has been very difficult, I think, for anyone joining a new business. So we have tried to make sure that they meet people virtually for coffee. We have had and involve them in the life of the firm. So we have online yoga. We have had a number of quizzes. We've had treasure hunts. We've had all the things that you would normally do. And in particular, we focused on our trainees, because I'm sure you'll remember when we were trainees that you learn such a huge amount by being in a room with someone, how they are on the phone, how they talk to their colleagues, and you pick things up in a way by osmosis in a way that is very hard to do when you are living alone and you're not in the office. So we've tried to take particular care of the next generation of lawyers, and I think this has been an extraordinarily difficult time for them. So where we can, we've tried to go the extra mile to train, to look after them. I'm sure that's the same for Edmund and Pelin and Emmanuel in-house as well.
Yes, thank you. Emmanuel?
Thank you. I mean, my personal prediction for the future is not a complete return to the way things were in the past. In a way, the pandemic has, basically forced the industry, not just my company, to just equip themselves to operate remotely, in particular with those working in the field and meeting healthcare professionals. And I think that'll be here to stay. Probably the way that these colleagues will operate in the future, will be partly the way we're doing it now and partly the way they were before. Internally, I anticipate probably a bit less business travel in the future, because we've just got, realized that actually you can do a lot of things virtually. It works relatively well, and the technology is there to help us to operate in this way. But I would say still a form of return to normality, because of the importance of being in an environment, and not just my department, but we've had new joiners, of course, join the company since February, March. They've been purely virtually onboarded. They've been working from home ever since they started, but that's not really sustainable in the long term. It's important for team cohesiveness to be able to see your colleagues regularly. If only so that the more junior members can learn from the more experienced ones. So yeah, that I anticipate a sort of mixed picture, picking the best and how we equipped ourselves from the pandemic as an opportunity for the future, but at the same time a healthy kind of return to normal. So at the moment, the company is sort of doing surveys with employees to take a temperature check on what people would like to do in the future. And so I think it'll be really interesting to see the results of that.
Are there any already temporary results on the efficiency side? Are there any specific issues which can be maybe even in the future better done this way, digital way, thanks to the experience that we are having now?
Yeah, I mean, without going too much into the specifics, I think certain types of business meeting, I think have been demonstrated to work well virtually. And so it's possible that they might shift to purely virtual mode. But I'm sort of a bit speculating right now as to that. I think there will continue to be business travel for, the very important negotiations, if ever there's a court hearing in the future. Or these kind of significant events. But I think perhaps for some of the more regular business meetings, there, I anticipate that maybe there will be a bit less travel involved.
Thanks, Bahadir. I think it was Winston Churchill who said, "Never waste a good disaster." And I think that's a good message for all of us. There's 3 points that that would come to mind for me. First, Technology, the adoption of technology that we've seen in the last couple of months is not going to go away. It's probably going to become part and parcel of our daily lives. I agree with Emmanuel. We probably are going to scroll back a little bit because, you know, human interaction is very, very important. We've done the survey within my firm. Obviously, it's a lot smaller than Emmanuel's corporation. And a lot of the people have found that they're more efficient working from home. We probably will have a couple of days back in the office where everybody gets to interact with one another. We can't do that yet with the current restrictions, but once those, you know, are sort of lifted in Singapore, then we're going to have about 1 or 2 days where people come together, exchange ideas, meet one another, especially for the new hires. And for the rest of the time, they work remotely because that's been efficient. So remote hearings, remote arbitration hearings, remote meetings, that's going to be here to stay. The second point I would say that I think we all should bear in mind is I would call this make your requests. A lot of people think that with technology, we can't do certain things. That's not really true. Don't listen to the IT guys when they say, oh, this can't be done. They always say the same thing. This can't be done. They're wrong. Anything can be done if you put your mind to it. I mean, even assessing a witness on screen, I sit as an arbitrator. I want to see the witness. I also want to see the counsel who's calling that witness, because sometimes I get better body language from him than I do from the witness. And you can see him sort of like, you know, when the witness sort of screws up, and I want to be able to see that. So have big screens, have projections. You can blow a witness's face up to the size of your screen much better than in real life. Make your requests, and there's always a way to do it. Technology can be adapted. And, you know, the last point that I would make is this has taught us, actually, even though we're remote, that the world is getting smaller. The fact that we can come together from all the different places we are at right now in this webinar and exchange ideas is proof positive that the world is getting smaller. Gary Bourne, who needs no introduction in the world of arbitration, was asked, you know, in SIEC, have you seen a drop in cases because people can't come to Singapore to arbitrate? And he says, no, we've seen more cases because people like the rules, people like Singapore as a seat. We can do arbitrations from anywhere in the world right now. We can do SIEC arbitrations. We can do ICC arbitrations. We can do LCI arbitrations. You choose the center based on the rules. You choose the seat based on whether it's pro-arbitration or not, and you have your arbitration there. You might be miles away, time zones away, but you can choose where you want to resolve your dispute. So the world is getting smaller. It creates a smorgasbord of new options for people.
Can we say that the judges also are becoming more transnational?
The judges are becoming more tech savvy. I'm not sure about transnational, but I think it's fair to say that in many progressive jurisdictions, we don't just look at our own jurisdictions for guidance. For example, Palin mentioned that case that came from Austria. We look internationally to see what's happening in arbitration with interpretations of the model law, with interpretations of how you use the New York Convention. I think if you are going to be serious in arbitration, you have to take a very international outlook on things.
Yeah, thank you. Pelin, in conclusions, also in a very comparative analysis.
Sure. So first of all, let me continue from where Edmund stopped. First of all, my future thoughts for arbitration is more optimistic. One of the criticism for arbitration is that arbitrators and arbitration practitioners are a small circle of friends and who appoint or reappoint each other. COVID-19 might have opened the doors to a broader democratization of international arbitration. There were many free webinars for younger generations, some of them really led by Gary Bourne, and geographical barriers were disappeared. So pool of arbitration practitioners may be diversified in this time. Again, as we spoke today, effectively managing online hearing requires arbitrators to manage the interface, document submission, and communication tools. Arbitrators will also have to be mindful of the cybersecurity, data protection, and confidentiality of the voluminous documents. The increased demand of technical skills may also create new opportunities for younger generations, for younger practitioners in arbitration. So, of course, the time will show us whether COVID-19 will help the younger generation to enter into the arbitration world, or the criticism on undiversified structure of the arbitration community will continue. But for me, I'm really on the optimistic side, and hope to see that this pandemic will help us at least in that respect.
Thank you very much. Thank you to all of you for being cautiously optimistic, realistically pessimistic, but I think the oscillation is towards optimism, yes. And this is what we need. And if people like yourselves working really on concrete and tangible issues and fact-based issues are cautiously optimistic, the rest of us can also be in confidence optimistic. So thank you very much. Thank you to Annabelle Thomas, to Emmanuel Sora, to Edmund Cronenberg, to Pelin Baysal, to Günen Partners for organizing this, conceptualizing this session. Thank you to all the participants. Session is over. The debate is still on. Thank you. And I wish you to all healthy days, joyful days. Thank you.
Thank you very much.
Thank you all.
Thank you.